consideration the specific circumstances of that person when describing, what could happen. If that particular remedy was undertaken. The same with the use of a ventilator. The most also includes whether or not the person wants non-invasive ventilation, which is very different than, for example, a trach or some other tubes that are put through the nose or mouth. Whether or not the person wants to be transferred to a hospital. So once those issues are discussed between the patient and the practitioner, the emergency issues on the first page are determined and then signed off by both the patient and the practitioner, who has to basically swear that he or she had an in-depth discussion with the patient. On the other side, page 2, is what happens once the person has gotten through the emergency. That is, whether or not the person wants artificial fluids, rather than, if the person is unable to drink, artificial nutrition, hydration, dialysis, and any other wants or rejection of treatment that this particular patient has discussed with his or her practitioner. Now, the dispute arises when a patient is under guardianship, and I'm not talking about when a patient is not under guardianship. So there's a presumption that if a person is incompetent to make informed medical decisions, he or she can't engage with his or her doctor. Now, that's not a foregone conclusion, but of course it needs to be determined by a court, for example, with information and input from the patient and the doctor. If it's clear that the patient does not have the capacity, the question is, can a guardian sign this? Can a healthcare proxy sign this? Well, the law basically states that a healthcare proxy can if it's not specifically prohibited in the healthcare proxy itself. That is, if the patient has not said in the healthcare proxy, I don't want my agent to sign a MOLST for me, then the healthcare proxy can address these issues with an in-depth discussion with the practitioner and execute this. But my view, and I think it's supported by the documentation that's provided on the MOLST website, that a guardian cannot sign the MOLST unless there's a court order. And there's, I'll make specific reference to, I think it's page 61 in your materials. It looks like this, and it's called Massachusetts Medical Orders for Life-Sustaining Treatment, Answers to Frequently Asked Questions for Lawyers. And the second to last question is, who can sign a patient's MOLST form? And the last sentence states, I guess it's one sentence, a valid MOLST must be signed by both the patient and the healthcare or the healthcare agent, but only if the patient has lost capacity or the patient's guardian. Now, then it says, and the intending physician, nurse practitioner, physician's assistant. If a patient has not appointed a healthcare agent before losing the capacity to sign a MOLST form, no one is authorized to sign on his or her behalf unless a court-appointed guardian is granted the authority to do so. I didn't write this. So this is what it says. So if you look in your client's chart and there's a guardianship and the guardian has executed the most, then I would file a motion, I recommend that you file a motion to rescind the most, to advise the practitioners, the medical practitioners, that this is no longer a valid most. Usually, I don't run into any problems with the opposing counsel on this. They'll usually pull it and then proceed to file a petition to expand the guardian's authority, which is, and seek a substituted judgment determination from the court.
Good, thank you, Laura. So that really begins to open up some conversation. And I wonder if anybody else, I know I was looking at Dr. Warren, and I'm sure Lisa have a few, and Jackie, I'll have a little bit to say about that. So who would like to start off? Do you want to talk from I think from the medical side and the family would be a good place to start.
Just would want to make a quick point. A lot of these episodes are predictable because there's signs that things are declining before. So as a healthcare provider, earlier trying to get the expansion of the guardian's power would be much more helpful than having to rescind an order because they did it inappropriately. So I think this is what we look for. We look for general agreement and discussions as we're looking towards the future. And once again, when we looked at resuscitation, the statistics are pretty dismal. And I always say in some ways we think we're making these huge decisions, but the reality is if people are going to die, resuscitation may not be the thing that helps them. From this perspective, though, there's a lot more treatment choices that come into play. So I think it's important that we proactively expand those powers if needed, and just be truthful that things may not take the right direction.
Great, thank you. Lisa?
Sure. So the issue is when you need to get into court. And as I mentioned before, it's my strongly held belief that these cases should not be in court. I think there's authority for that in the Dinerstein case. When you take a look at Dinerstein, which was a 1978 case, that case stands for it's a confusing case because it starts to create categories of who can consent to a DNR, who can't. What happens if you have a family member guardian or a non-family member guardian or no guardian, family members who are not guardians, and who can consent. And I'll tell you that the Mental Health Legal Advisors Committee created an entire chart that shows, it's sort of a flow chart. And you can find this on their website. It was created in 2013, and it shows, well, what happens if there's no family, who can sign a DNR, and what happens if there is loving family, who signs, and what if there's a guardian or there's not, who signs, what if there's a controversy, parties don't agree, what if there's no family, what if there's a chance of recovery, and it creates what looks like a science, but it's not. There's an art to this. It's not a science. This is you're taking that Dinerstein case from 1979 and creating all of this, I think, is more work than needs to be done. I think it's really quite simple. You want to try to keep people at the end of their lives out of court. When you go into court and you deal with a substituted judgment determination, you're dealing with appointing counsel for the incapacitated person. Counsel goes to meet with the incapacitated person. That person is trying to deal with end-of-life decision-making, and to have a stranger walk in and start talking about these issues, a non-medical stranger, after this person's probably already discussed it with their own physician to the extent able, is, I think, just more doings that are not really the right thing to do. So I would tend to be reluctant to create a whole substituted judgment court proceeding over these MOLSTs. The committee that developed the MOLST also developed this excellent facts sheet that Laura read from, and I think it's very, very helpful. But it's not a primary source. It's not a statute. It's not case law. It's not even tertiary. It's not even a law review article. It is literally a document that was a fact question and answer sheet. It's a proposal that was drafted in July 2012, and it is very helpful, but I don't think that it creates a obligation for people to go into court. I think the Dinerstein case, if you read through it, takes a couple times to get through it because it is rather confusing. It's 1979. Keep in mind the landscape in 79. This was when we had the Rogers case, we had the Bassett case, we had Sakowitz, we had all these cases, many of them decided up in Western Mass, which places a precedent on the protection of vulnerable citizens of the Commonwealth. And we had this whole movement, the Ritchie lawsuit, we had all of this movement to protect the rights of the incapacitated individuals. And since then, 1991, the healthcare proxy statute. We're looking at mults, we're looking at DNRs. The whole landscape has evolved, and now we have people who can mediate these disputes privately. We have people who can deal with these issues. I think Dinerstein, even back then in 79, stands for the proposition that you try to keep these matters out of court if you can, and that the ones that should make it to court are the ones where you have a Sakowitz-type situation where you're asking to make a negative decision. You're asking to terminate a treatment or withhold a treatment that would otherwise give a person an opportunity to recover or go into remission. That's vastly different than looking at somebody who's at end of life, for whom a DNR or MOLST is ripe because they have no chance of recovery and have no quality of life. And for those individuals to let nature and God do what nature and God do, which is to take a person when the time is right, you let that happen without creating a stir around it. And so I think Dinerstein can be very aptly distinguished from the Sakowitz negative decision. Dinerstein is a positive decision, and you let nature take its course, preferably without court.
So just to give you my 2 cents on this, in the Dinerstein case, there was no guardianship. So I'm completely on board with what Lisa says, as long as there's no guardianship. If there's a guardianship, there's already jurisdiction in the court. And in custody of a minor and in care and protection of Beth, the SJC over and over again distinguishes those cases from Dinerstein by pointing out that when the court is already involved, when there's already a guardianship, as there were in care and protection of Beth and custody of a minor, then it's anathema to the court to have some other individual, private person, committee, ethics committee, or physician make the determination for an incapacitated person who's unable to give their perspective.
Okay, thank you, Laura. It's
Very quickly.
another good point, Jackie. And then we're going to go to question and answers real quick before we end.
Quickly, I have to disagree with Laura and agree. I have my own position. I think that there's enough law there to actually interpret it either way, but I think there's law in both. You can read Beth, Care and Protection of Beth, and you can read Matter of Spring to expand Dinerstein to say that basically guardians can make DNR decisions. So I won't go beyond that. But what I do have to say is that as a state agency, we name many guardians, and we name a lot of professional guardians. We actually have a list off of which we pull professional guardians where there is no family, and there is nobody stepping up to the plate to be a guardian. And the truth of the matter is that very few professional paid guardians will agree to do a DNR order without court approval. So that's just another little
Great.
piece.
Okay, so one thing I will say is you can see that this is a very good topic that get a lot of discussion on our panel. So we have a few minutes, and so it looks like we have a question in the audience. Gary?
First, Oh, thank you for the discussion. That was very helpful. Can I ask, how would you incorporate custody of a minor with the loving family exception? So if there already is a guardianship and everybody's on the same page, it's
Thank
a loving
you.
family,
Yeah,
what does
Lisa.
one do next? Lisa?
Is that a question for me?
Yeah, Lisa.
Okay, so
And
there's
then for
already a
that, please.
guardianship, and the question now is, do you go into court with the existing guardianship under a substituted judgment?
When
You're
is the
saying
loving
everybody's
family
in agreement.
exception? When you have the loving family exception?
Okay, so there's no loving family?
There is. There is a
There
loving
is family, and you've got, and the family member is guardian?
Family members, guardian, consensus among the family. I'm sorry.
Consensus.
And then the medical professionals are also on the same page.
I would stay out of court under that circumstance. I think that one is the low-lying fruit. So, you know, my feeling about this, about the science versus art issue, is that the only time you should go to court is if there is some political reason to do so because there's an actual controversy. Let's say you've got family members and a non-family guardian disputing as to whether or not to sign a MOLST or a DNR. That's political. That's problematic. That's an actual controversy, and that goes to court.
So this is geared kind of towards Jackie. So given that I am in a role as a non-family member guardian, and given what Dr. Warren said about that some doctors will say, you know, extend a timeline for, you know, somebody's life expectancy, how do we get into court fast enough if somebody's got less than, you know, a few months to live when the process for DDS takes so long to get a DNR?
It's a good question. If it really is a very pressing matter, the legal office needs to expedite it, and we need to, some of the courts will expedite it, some of the courts won't. So sometimes you don't. And some of the non-family member guardians will consent, and some of them won't. It's a shame if you don't get your DNR when you need it.
And file a motion for short order of notice and even do away with the notice requirements if the court allows it.
You can file an emergency, you can try to do a walk-in. Some courts really won't allow it, but most of them will.
I think, should we go there first? I'm not sure what order you're handing out the mics here. I've lost track. Thank you.
So when you're talking about affirming a healthcare proxy, so probably for Lisa, when you say it goes away once a patient regains capacity, when we're talking about a patient who is never going to regain capacity, would you take the position that the affirmed healthcare proxy is permanent, essentially?
Yes.
Thanks.
Great. I know, okay, one there and then Elise up here.
Yes, hello. Carlos Zimmerman Diaz from Department of Mental Health. I have a question about the mechanics of this. When you're going into court and you bring under the Mental Health Legal Advisory Committee flow chart, once you're in court, according to them, it's substituted judgment. So actually, in that situation, aren't you asking for the judge to issue an order to authorize a DNR, DNI? Because a guardian could not consent to something that required substitute judgment. And in that case, doesn't that put the judge in a really tough spot?
It does. I think we're probably going to agree that that's when you have the whole mechanism for a substituted judgment. And it's going to slow it down because you're going to have to get counsel appointed. Counsel has to go out to the hospital, has to meet with the incapacitated person. You schedule another hearing, you get back in front of the judge, you argue it, maybe a GAL is appointed, and it's a lot of doings.
Okay, thank you, and right here.
It's Bob Fleischner. There are some judges who, if you go in for those sorts of orders, won't enter them because they'll say, this is the guardian's responsibility, and I don't care if the guardian won't exercise it. I'm not going to take them off the hook. And just to comment on what Laura and Lisa were debating about, shortly after the Rogers decision, there was a law review article criticizing substituted judgment, to which Judge Liakos, who wrote Rogers, wrote the response. And he agreed with Laura that you have to go to court no matter what, under any circumstances, whether there was agreement among the family members or not, that only the court had the jurisdiction to enter whatever came under substituted judgment. But he agreed with Lisa that the vast majority of these cases never get to court because there's no debate. So suppose he knew what he was talking about. But
I'm sticking with Judge Liakos.
Elise? And I think that will be
Yeah.
our last question. I'm sorry, we are out of time.
Thank you. On the most, I do think there is some case law, too, that would support that the court really isn't there to rubber stamp things, that they do want to hear controversy. But to Jackie's earlier point, there are some vulnerable people that we need to sometimes make sure that everybody truly is in agreement because there's been an education on the issue. Which takes me to my question for Dr. Warren. I was wondering if you could explain a little bit more about the stats related to resuscitation. In one of your slides, you had mentioned that in less than 5% of the time it's successful. Is that just in a particular setting? And could you just expand on that a little bit?
So studies look at resuscitation in hospital settings, and they really between 5 and 15%, and that is all patients that are receiving resuscitation at a hospital. And that means leaving the hospital. It doesn't mean leaving the hospital necessarily not on a ventilator or going back home. It could be to a long-term care facility. So, a generous is 15%, and that includes younger patients that come in with heart attacks, traumas in the emergency room. It's not the general patient population we're taking care of.
Okay. I do want to thank the panelists and for being willing to have a discussion that was a little bit uncertain, and I think still is. I did want to mention a resource, if you don't know about it already. I believe some of the materials may be in your handouts that you have. There's a website, Honoring Choices, and you can find it at www.honoringchoicesmass.com. This is a website where there is still discussion. They're looking for questions and information for the Department of Public Health, and they are aware that this is a difficult topic, and there are some, there is a statement about what, the law says, but I think this is still a work in progress, as we can see. So please use that and post questions, and certainly, I'm sure the panelists will stick around during the break if you have any further comments. Oh, and there are snacks, I'm being told, for you to take a break, snacks, and I think we're back in here at 11. Thank you very much.